Hi, everyone. Thanks for joining us today. I'm here with Charles Cottrell, an estate planning attorney who is going to share his wisdom, insight, and years of experience with us to help us plan our death more efficiently. Hi, Charles. Welcome.
Hi, thank you, Willow. I appreciate the opportunity to talk here today.
Thank you for coming. I'm excited to I'm going to go ahead and just jump in and get started since I know we have limited time. Okay.
Sure.
Cool. What is estate plan? Why is estate planning important for individuals and families, regardless of their wealth?
Right. So, estate planning, let's define that real quick. It's a lot of different things. It's not just documents necessarily, although we do it with documents. For example, you all know that wills are a big common part of estate planning, powers of attorney, possibly trusts, deeds to your properties so that they could go either to your family members or to a trust or however you want them to go. All that can be part of estate planning. Why is that important? It's important for everyone because we all have something. Almost all of us have something, and we almost all of us have loved ones that we want to take care of. And so, how do we accomplish that? A lot of this is we would like things that we could do for ourselves or for our loved ones when we're well and able or alive. We can't do anymore if we're incapacitated or we pass away. And so, how are we going to accomplish helping them out, making sure our wishes become realized when we're not able to do that for ourselves? So, that's a big part of estate planning. And the neat part of that also is we call it making your own rule book, your own set of rules, how you want things to go. Because in life, we're subject to everybody else's rules. There are so many laws about what you can do, how fast you can drive, when you can turn right or left, those kind of things. But in estate planning, we have a unique opportunity to make some of our own rules. And that's important no matter how much money you have. Even if, for example, you might just have a few pets. So you want to make sure your pets are taken care of. So you are able to accomplish that with estate planning.
Beautiful. Thank you so much. Yeah, that's a lot more than I was thinking about. I always thought that you needed that was for the wealthy too. So it's really helpful to understand that it's for everyone to plan for everything that's important to them.
Yes, historically, wealthy people are associated with estate planning because there's all this tax planning that used to be done. It used to be if you had over $640,000, you had to do special planning, or else the government would take, basically half of your stuff that exceeded that amount. And so estate planning equaled tax planning. And the big revolution in the past 20 years is that it's more about benefits planning because the estate tax limit now is $13 million per person. So if you have more than $13 million, you have to come see me right away. I tell my clients that, or my prospects that, but not everybody has that, right? So what else can we do for you? And the benefits planning, the making sure that, you're taken care of using your money first. But if you need help from the government, there are ways to qualify more quickly. And so again, anybody has the risk of becoming incapacitated, needing skilled nursing care, those kind of things. And so that's why, again, it's not just for the wealthy.
Thank you. What is the biggest misconception people have about estate planning, and how do we address that?
Yeah, a lot of people think that they just don't need it. They just don't have enough stuff that they need it. I just have a car, I just have a house and a bank account. Why do I need estate planning? And so, that's a good question. That's a valid question, right? And they might only have one child, so it's all going to go to that child. Well, again, if incapacity strikes you before you're able to do anything, it's too late. And we'll get into that more, but it's so important that while you're able and alive to designate people to take care of you. I mean, what if you become incapacitated? You're in the hospital, you're in a skilled nursing facility. Who do you want to be making decisions about your care? Who do you want to be looking after you to make sure things get done and make sure your finances are taken care of? If you don't plan ahead, you're subject to some very, I would say, bad consequences because you can't pick your person. Someone might file a guardianship, conservatorship for you, and we can talk about that more too. But those kind of processes using the court, now you're subject to the court's rules. Remember, we talked about making your own rules? Well, now we're not in making your rules anymore. We're following the court's rules. And what if, and this has happened before, and I'll kind of talk about this little story. Someone applied to be her second husband's guardian. So she applied to court because there was no power of attorney and no medical, patient advocate designation. So she applies to the court to be the guardian. Well, the guardian ad litem is the person that does the investigation. And they come and they say, oh, you know what? You're not really suitable to be the guardian. We're going to have a court appointed guardian do it instead. And so she's the one that started the process, and yet she's not the one that's going to be in charge of it. Isn't that kind of sad? So that was a surprise to me that could happen, obviously. So again, if this person had done powers of attorney, medical powers of attorney, or patient advocate designations, making your own rules, and this is really important too, not just pick one person, because you don't want your whole estate plan to blow up if one person can't do it anymore, right? You said, oh, well, everything is going to be done by Will. Will's going to do all my stuff for me. Well, what if Willow's not around, or she moved somewhere, or, then my estate plan doesn't work anymore. So I like to have at least 3 people, and I call it the lineup of people that are going to do things for me. And so you need that as well, because you want to make sure that no matter what happens, your estate plan works for you.
Wow. Well, that leads me to the next question of what are the other risks? Because that's one risk, and I'm sure that there's a lot more to delaying planning for the estate.
Yeah, yes, exactly. So if you, again, the guardianship conservatorship thing is a big, big risk, because if you lose your capacity, you can't do it. You just can't do it. And there's nothing we can do about that except filing those probate processes. And now we're in the court. So some of the risks are pretty much more financial, I would say, because if you don't have your power of attorney in place and you go to a nursing home, okay, now you're in there and you want to try to save some of your money for your kids, or for your care, extra care for you, the court might not let you do that, because how we save your money is we have to give it away to somebody. Okay. And guess what they don't like to do? Give your money away to somebody, because that's kind of like stealing. Okay. Unless you've authorized it, and you can't authorize it if you're in this situation. So the courts would rather conserve your money and make sure that it's all spent according to their wishes, not your wishes. So that is a big risk. Another big risk, again, for timing and benefits planning is we have something called 5-year Medicaid planning, and that's very useful. Let's say you have an extra property. A lot of people here have a cottage up north. That's a big thing here.
Yeah.
Or they'll have a brokerage account. And we can put that into an irrevocable trust. It's called a 5-year Medicaid trust. And that starts a look back period. And if we get through that 5-year period, we can keep some of those assets. We don't have to spend them down. And we can make sure they go to our loved ones later on. And we're fine. We're able to qualify for benefits and still keep something for the family. And that's like what everybody wants. Nobody is trying to say, I want to save all my assets for my family, and I want the government to pay for everything. But almost all of us has something we would like to pass on to other people. And this gives you the opportunity to do that. And so if you don't have that in place, you miss those 5-year opportunities. You're already in a nursing home. We've lost that chance to do that.
Wow. On a bigger picture, from my perspective, what that, if I'm understanding you correctly, so a lot of the things that people work their whole lives to pass on to their family or leave as a legacy, if they don't actually take action and plan ahead now and do that legally, a lot of that stuff gets lost if they wait too long or delay actually talking and planning, estate planning.
That's exactly correct. Yes.
Wow. Yes. So then that leads to the next question of power of attorney. What is that document, and why is it such a critical part of estate planning?
Yeah, so I say to most people that I meet, I say, if you do nothing else, just get your financial power of attorney, because that's the most crucial document to get, especially in this region where we are right now in West Michigan. And what that does, it has a lot of different names. So let's kind of go through that too. It's a financial power of attorney, durable financial power of attorney. What else do we call it? Just power of attorney itself, financial, durable. POA is the abbreviation. A lot of people use the word POA. So what's a POA? Well, it's the same thing, power of attorney. And what that does is it appoints one person to basically stand in your shoes. and do whatever you could do for yourself financially. Now, the word durable, that goes back to a historical thing where back in the day in jolly old England, where people were sending people over maybe to India or different places to, do different things for you. Your agent under the power of attorney could only act for you if you yourself were competent. Okay, so that was called the normal power of attorney. So then they had to say, well, what if you're not competent anymore? How do we make this stay working? And that's where the word durable comes from. So a durable power of attorney means it works even if you're not competent. And the funny thing now is almost everybody associates a power of attorney with a situation where you're not competent. But another big area where we use those is, let's say, and I did this when I went through a divorce. I was in Georgia and I needed someone to be my agent to sell the property, for example. So I did what's called a limited power of attorney, and I appointed someone with the powers just to sell my house. Okay, that was the only power they had, but they could act on my behalf while I was somewhere else. And so that's how that kind of works. So the general durable financial power of attorney means someone can do basically everything for you could do for yourself financially. All right. And the main way we use this in benefits planning is, let's say you're incapacitated. You've got too much stuff. You're in the nursing home. How do we get you qualified? Well, one way is you can spend $15,000 a month, and pretty soon you'll be qualified, right? Because you'll run out of money. But the other way is to, again, with the gifting power, your agent is able to give some of your stuff to a loved one or to an irrevocable trust or something like that, and get you qualified more quickly. And that really can benefit your situation immensely.
Wow, that's a lot right there. If I understand you correctly, so the power of attorney is important because you're designating who has the power of your finances, and if you want different people in charge of different things or to share responsibility during time periods, then you can delegate specific people for a limited time to specific areas of what you need.
That's correct. That's correct. And the important thing to mention while we're on this topic is that we see many powers of attorney done by other attorneys, and they're not powerful enough. And that's a big problem because if you don't have the powers to gift or to create trusts or do move assets around, then the power of attorney doesn't help you very much. And we run into that many, many times. Like, boy, we wish we could help you, but you have a nice power of attorney, but it's not powerful enough to do what we need it to do. And so meeting with someone that has experience in the benefits planning side. So you meet the old stodgy attorney that does estate planning and taxes. They're not going to put these powers in because they don't necessarily think about benefits planning as much. So it's helpful to meet someone that does the benefits planning side of estate planning.
Thank you for that clarity, because yes, the more detailed and informed the paperwork, the more clarity in that experience. I've seen a lot of it from my perspective.
Sure.
And I also want to put out in this point in time too, that even though right now we're talking about powers of attorney, and there are different ones for medical as well. The power of attorney is over finances. And just for anyone watching, we will talk at a different time about medical power attorney and what that is and the different options. Because you do not have expertise in that, correct?
Well, I do medical powers of attorney as well.
Oh, perfect. Then would you like to explain the difference? That would be helpful.
Yeah, absolutely. So,
okay, cool.
Everybody's heard of a living will, I would think. And estate planning attorneys don't like living wills. We feel that they kind of help the hospital more than they help the patient, because they kind of say what the hospital can do or not do for you. It gives them a lot of options and instructions. Okay. We don't necessarily want to do that, in my opinion, anyway. What I like to do is appoint agents. Again, they're called patient advocates, but they're an agent, like it's because it's a power of attorney, right? And they have the discretion to do whatever they feel is best for you. based on your wishes, based on knowing you. So you pick people that have the same values that you have. That's really important. Okay. And then again, they're making these medical decisions and they're not limited by what you put down in a checklist of I want this or I don't want that. Now we make a private paper that doesn't go to the hospitals or the doctors where you can give some instructions to your patient advocate to kind of guide them if you so choose to do that. But I like the idea of full discretion. I really do. I could say to somebody, my agent, let's say I pick my sister. My sister is my patient advocate. So, and she's a scientist. She's a medical scientist. So, I would say to her, if there's a chance for me to get better, then let's do things to make me get better. But if there's no chance and I'm on a machine, I don't want to be artificially kept alive in that situation. And that's what most people have something like that. They would like to be, if there's chance, they'd like to be treated. But if there's no chance and they're just suffering or their quality of life is very low, then they don't want to have as much treatment, right? So, and another thing that's a very important feature of Michigan's patient advocate designation is there's a part where you actually say or authorize your agent to end life support. You don't have to sign that part, but if you do, it means they will have that as an option. And so I would say 99.9% of the people that I've had, they sign that option.
Wow. So with that, oh my gosh, I know that's the next question I was going to ask too, is more about the patient advocate designation. So would that eliminate the DNR? Because I know that there's two different kinds of DNRs. So would that take that out of the question too? And the patient advocate would make that decision at that time?
Well, they work together. So the patient advocate can actually sign a DNR if the person can't sign it anymore. Okay, so that's one power we can give to the patient advocate. My understanding of a DNR, and that's something you get from your doctor, not from me. So that's the document that I don't give to people.
Okay.
But it only applies when your heart stops. And so that's, from all that I've heard, a DNR is a very limited situation. Your heart has stopped. Do we resuscitate you or not? Do we give you, electric shock or the CPR, those kind of things? If you have a DNR in place, we won't do that. But that doesn't apply at all to like cancer therapies or anything else, right? That we go along, even surgeries, those kind of things. That would all be done by the patient advocate making those decisions if the patient, him or herself, cannot make those decisions.
So that's fascinating. And thank you for explaining your understanding of what a DNR is. I will get more clarity of that in the future. As far as patient advocate designation, if someone doesn't prepare for this, or is there anything else that you like to add before we move on about the importance of having this in place prior to serious illness or unexpected illness or incapacity?
Sure. Well, the biggest takeaway is if you don't have it in place, again, we're going to court. So we don't have the financial power of attorney in place. We have to go to court and get a conservator appointed. The conservator is in charge of your money, and they're again restricted by the court. If we don't have the patient advocate in place, we have to go to court and get a guardian appointed, guardian of the person. All right, and they'll be making your medical decisions. And if it's not your second wife because she applied for guardianship and she didn't get it, now it's a professional guardian that's making your medical decisions, and you have no way of knowing what their values are, or hopefully they do a good job, but there's no way to express your wishes to them. And so the risk is that you're in the hands of somebody else that you never thought would be making your medical decisions for you. And I would say making your medical decisions is there's nothing more intimate or important I can think of than that, in my opinion.
I would highly agree with you. So if I'm understanding this correctly, and to recap, if someone does not choose to advocate or designate a patient advocate, then they are left to chance who they get that is in charge of the rest of their experience, which can be very scary.
That could be very scary, yes.
Oh, all right. Moving on. Thank you for that. That's a lot. That's huge. And that's new to me too. what are the consequences of not having a will or a trust when someone passes away?
Right. So maybe people don't all know this, but the state of Michigan was nice enough to give you a will. So we all have a will. And it's called intestate succession. All right. And so it's designated down there. If you're married, it goes to your spouse. If you have kids with your spouse, some of it goes to your spouse, some of it goes to your kids. If you don't have a spouse, but you have kids, it will go to your kids. Well, what if your spouse has kids and you have kids and you have some kids together and some kids aren't together? And it covers all these different scenarios and how much of each person gets. But I can't imagine that most people would want that necessarily, because you can't get any chances, for example, to say, when we do wills or trusts, we give you what's called a memorandum of personal property. So there's certain items that you can give to a certain person, like the jewelry, family jewelry. You want it to go to, your daughter because your daughter likes jewelry and your sons don't care about jewelry. Well, but dad has the tools and the golf clubs and all that kind of things. And so, he might want those to go to his sons or whatever. So you lose that opportunity completely if you don't have this will in place. But the bigger problem, even than who gets what, in my opinion, is who's in charge of your stuff? Who's in charge of your will? Let's say you have a spouse, your spouse will be in charge of your estate. This intestate succession we talked about. No will in place, your spouse is in charge. But maybe you wanted one of your kids because it's your second or third spouse. You don't really want them in charge of your stuff. Or what if you have 4 kids and you pass away without a will? Well, all 4 kids have equal priority to be your personal representative. So they're going to have to fight over or decide, which one's going to be in charge of it. Okay, because we need one or 2 people, and the rest will have to waive their priority. And that could cause a lot of conflict there. You might end up with someone you didn't want. So if you pick your people, pick your personal representative, and pick who gets what, then you've alleviated some of those problems.
So it not only helps our own experience, if I understand you correctly, but it's the nicest thing we can do to our loved ones to not put them in the position to try to have to figure it out, and instead ask them and have a conversation up front and allow everyone to honor your wishes or honor our own wishes.
Exactly. And then there are other things that you miss out on as well. For example, if you have minor children, if you do a will or a trust, you can plan for that. You can plan for minor children. That's one of the questions I ask everybody. I say, what if you have minor children when you pass away? They say, well, my kids are 35, 40. Well, do they have kids? I say, oh yeah. Okay. Well, what if one of your kids predeceases you and now this is going to the minor child? Do you want them to be in charge of the money at 18? Because that might be the case. They might be in charge of it at 18. Well, do you want to give an 18-year-old $300,000? That might not be the best idea. And so again, you miss these chances to not put your rules in place if you don't have a will or trust when you pass away.
Wow. And how else does estate planning help families avoid financial and emotional costs other than that aspect or the cost of probate?
Right. So if you want to avoid probate, and I encourage people to try to avoid probate. Probate is not terrible. You have a will, let's say, and you think, a lot of people, first of all, they think if I have a will, I don't have to go through probate. And so that's the biggest misconception in estate planning. A will equals probate. So just keep that in your mind. Will equals probate. Okay. Now, there are ways to avoid probate. And one of them is, for example, if you have a bank account and you have a beneficiary, okay, then it doesn't go through the will. It goes right to the beneficiary. If you have a bank account and you have a joint owner, it goes to the joint owner when you pass away. For example, if you own a home, you pass away, the joint owner, like most people that are married, own the home as a married couple. It's called tenancy by the entireties. All right, which is a fun little term. And they own the home, and one of them passes away, it goes to the survivor. Okay, so that's fine. And a lot of people say, well, you know what? I'm just going to have beneficiary designations on all my accounts. And I'm going to do a deed that adds somebody on. We have something called a ladybird deed. I don't know if you've heard that expression or not. It's also called an enhanced life estate deed. And what it means is basically while I'm alive, I own the house. But when I pass away, I'm going to give it to my child. And I put my child's name on this deed. And what's nice about it is it adds a beneficiary to the house. But at the same time, I can still sell my house and do whatever I want to with it. So I'm not obligated to get signatures from my daughter or from whoever. It just means that if I die and I have this house and this deed is in place, it just goes to them. Okay, so that's a way of avoiding probating the house. So a lot of people say to me, well, we'll get beneficiaries on all the accounts. Charles, we don't need your trust. We don't need your will. And then I'll do the ladybird deed, and I've just saved thousands of dollars in estate planning, and I'm so clever. And I'll say, okay, that's great. Oh, that's great. What if your beneficiary passes away before you do? Where's it going to go? What if your beneficiary is facing a divorce or a bankruptcy, and you pass away and it goes to them? And they're like, oh darn, I wish this money wasn't coming right this moment. I wish I could hold on to it for a little while, clear up these issues, and then take care of it. Or we already talked about what if it goes to a kid, a minor child, and we don't have any way to really manage that money for them until later on, right? So their money will be wasted. I always say let's make sure the youngest age that people can get money is age 25, because 25 will get most people through college, trade school, some kind of education, and just maturing a little bit more. Your brain's just maturing a little bit more by the time you're 25. So those are the kind of things that you can do with estate planning, that if you want to do this, what I call the poor person's probate, that alliterates very nicely, then it doesn't always work. It might work in one situation, but it won't work in every situation.
Wow. I love your insight and expertise and experience. It offers so much that one that has not had these experience would not even know to look at, or could be a potential financial pothole that you're able to save them from. That's awesome. All right, my next question then is, how can estate planning protect assets from creditors and lawsuits during someone's actual lifetime?
Okay, so that involves a little bit more of complex planning, I would say, because what we're doing there is we're saying, okay, you have stuff in your hands and you want to protect it, right? You don't want someone to come along and take it from you. All right. So we have to kind of take it out of our hands and give it to something or someone. And so typically how we do that is we use an irrevocable trust. All right, which that scares people. Oh my gosh, I can't change the trust if I have an irrevocable trust. Well, actually, you can make minor changes to the trust. There are ways to make changes to the trust. It has to be done a smart way, but it's something we can talk more about maybe in another time, because it's very complicated. But you give away the assets into this irrevocable trust. I help you decide: are you going to keep control of them, or are you going to appoint someone else to be the trustee? So there's different levels of protection that we can look at there. And so now you don't have the assets in your hands anymore. So if someone comes along and sues you, you say, I'd love to give you this $200,000 I have in this trust, but darn it, I don't have the power to do that. Or I have to have someone else co-sign on it, and they're not willing to do it. Darn it. So I just can't give it to you. And so that's essentially how those kind of trusts work. So that's very good. I've had a few doctors that have used that kind of trust, or people that own several pieces of real property. And they say, you know what, no matter what happens to me, I want to make sure this apartment building, or these two houses that I own, that they don't get taken from us, if something happens to me, if I get sued. And so we can do that. There are a couple of important things there. Is we can only protect against unknown future creditors. Okay, so you can't come to me and say, hey, Charles, I just got sued. I need you to protect my assets, or I'm going to get sued. I just did something and now I'm going to get sued. So hide my assets for me. It's too late. That's a fraudulent transfer. And so there's a fraudulent transfer act, that Conveyance Act, that makes us not able to do that. They can claw it back and put it back there and take it from us. So it has to be unknown future creditors, have to do it ahead of time. A couple of advantages also, we talk about benefits planning for Medicaid. Okay. So Medicaid said, thinks that if you give away money that, that you could have used for your nursing home care, they say we don't like that. You should never spend any money. I mean, you can buy things, but if you give any money away at all, that's money you should have used for your care. And so we're going to penalize you for that. All right. And the way they do it with these trusts is they look back the day you apply for Medicaid. So you're in a nursing home now, you apply for Medicaid, they look back 5 years. Did you give away any gifts in the previous 5 years? And if you did, they're going to say, oh, if you gave away $20,000, then we'll let you qualify for Medicaid. You're qualified, but we're not going to pay for 2 months. Okay, that's called the penalty period. We're not going to pay for 2 months. And of course, to qualify for Medicaid, you have to have less than $9,660. It used to be 2,000. They just changed that number 2 months ago. So that's kind of a big news for us. So you have to have less than $9,660 to pay for, to be qualified for Medicaid. Nursing home costs $15,000 a month, and they're not going to pay for 2 months. So how are you going to handle that? You see the problem? Yeah. So that's where
Wow.
that's why you need an attorney oftentimes to help prepare for that. But pre-planning and putting some of your assets in this irrevocable trust after 5 years, for getting through the 5-year look back, that
Mm-hmm.
could be a very good plan for you. Money could be taken out of that trust by one of your kids, let's say, and they could use that money to pay for your nursing home during that penalty period, for example.
So estate planning to protect individuals on Social Security and Medicaid benefits due to an inheritance, that's kind of what you touched on, right? No.
Well, that's a little bit different. This is still for
Okay.
yourself. So that, yeah, we
Okay.
can talk about that next if you'd like.
Well, would that be the next segue in, or the 5-year irrevocable trust?
Yeah, we could talk a little bit more about the 5-year irrevocable trust. I think, again, I
Okay.
kind of already talked about it
Right.
essentially, but a couple more details of that. For example, typically you can have the income. You can have the income from the trust, but not the principal. So we call it an income-only trust. So you put $300,000 in your brokerage account into this trust, and the income comes to you, and you say, "Great, I'm using the income. It helps me to pay my bills every month to month." But the principal I'm leaving in the trust. Okay. That doesn't mean you can't buy something with the trust principal. You could buy a condo in Florida. You could buy a condo owned by the trust. See, that's fine. It's just not owned by you. It's owned by the trust. So that gives you a lot of flexibility. You just can't take the principal out and give it to yourself. You can't buy groceries with it, because if you buy groceries, then you're eating it. You're eating the principal. See?
So it
And
has to be an investment that will bring financial gain, or, well, I guess because even property, there's no guarantee it will bring financial gain.
not any gain, just exchanging for fair market value. Let's put it that way.
Okay.
You know,
Okay.
money went out and an asset came in, and they were basically essentially the same value. So
Okay.
yeah, so that you
Thank
can,
you for clarifying that.
of course, of course. And then what typically these trusts also work is, let's say you have kids, you can make them your principal beneficiary. So you can give them your principal if you'd like. You see, so you gave it away already once. So now you can give them money from the trust. You're not giving it away again because you already gave it away. So that's a way to give gifts to your kids later on down the line without running into the 5-year look back when you apply for Medicaid.
And so that, would those gifts be tax deduct, or they're not taxed?
Right. So for estate planning purposes, there's really no gift tax until we get up into the millions of dollars. Okay. If you give more than the $19,000 a year, it used to be 10,000, and it's goes up every year. If you give more than that, you have to report it to the government, but you don't have to pay any taxes on it. Okay. It just reports it. So if you give away $30,000, you have to report that you gave an excess gift of $11,000. And that $11,000 comes off the $13 million that you're allowed to give over your lifetime. Okay, so now you can give away $12,989,000, whatever. So that's how that works.
And it takes away probably another month off of your nursing home. So let's go to the next question of how can estate planning protect individuals on Social Security and Medicaid from benefit losing benefits due to inheritance.
Okay, perfect. So in this scenario, basically you have a child typically, or a grandchild or someone like that, that is getting SSI, which is about $800 a month. It's not a ton of money, okay, but it's something. And they're getting Medicaid health insurance. So someone born with Down syndrome, for example, would be a perfect candidate for that. Or other people just have, disabilities that they can't work. They don't have a work history because, if you have a work history, you can apply for Social Security Disability Insurance, SSDI, and that's based on the income that you earned while you're working. Okay, that program is not means tested. So it doesn't matter. You can inherit money. It doesn't affect your benefits. But this other program, the SSI, has a $2,000 limit. Now, I talked about this $9,660 limit for a nursing home. That's fine. That's the new Michigan rule. But for SSI and Medicaid, the limit is still $2,000. Okay. So this person, your grandson or your child, that has an issue their entire life. They can't really work. They're going to need this forever. They inherit $100,000 from you. Okay, that's going to knock them off benefits because their limit was 2,000. So now they've lost their SSI, which isn't much, but they've lost their Medicaid health insurance. And now they have to scramble to try to get requalified. So they have to either give away their money, or if they're able to create their own trust, there's a special trust for that that they can try to do. Or maybe they just have to burn the money down for the next few months and then reapply for Medicaid. And so did you help them at all with giving them that money? I would say no. You made their life more difficult, and all the money went to, their care anyway. It just got burned up, and then they're back on the government benefits again. So there is a way to give it to them instead of outright, here you go, outright, here you go. You put it in a trust. You're holding it in a trust for them. And it's called a special needs trust or supplemental needs trust. Someone else is in charge of the money. So they can't be in charge of the money themselves, but a sibling, aunt and uncle, somebody like that is in charge. And then they can use that money for their supplemental needs. Take them on a vacation somewhere, buy items that they need for make their quality of life better, buy a laptop for them, whatever, those kind of things to make their life better, and use that money for their benefit, but not knock them off their benefits. So the scenario where those come into play.
That's huge. It's actually the greatest service someone can do if they truly want to help the next generation or help their beneficiaries, is to actually plan ahead and make sure that it supports that person versus creates more a conflict and challenge within their life. That's huge.
Right, exactly. And to add on to that, the people might say, well, my clients might say, well, I don't have anybody in that situation, so I don't care about it. Well, I say, well, that could still happen though, right? You could still have a grandchild born with Down syndrome or some other defect or some other inability, to not be able to work, autistic spectrum disorder, something like that. So what are we going to do? And so what we tell them is we build this kind of planning into all of our documents. So it's an if then else. If this happens, then do this, else something else. So we build it in. That's what good trust planning does, because it works in every situation, not just some situations.
Well, and on top of that, someone doesn't need to have a disability to have a financial gift knock them out of a tax bracket or a loan or something else. Like, it could affect a lot of areas rather than just one. Like, I can think of a lot of the homes that I've been in and the people I've worked with, that would have been helpful in other areas as well, for sure.
Absolutely. And so even if they don't have this is another, I don't really quite I wasn't planning on talking about this, but for almost all of the kids, what I like to do is say, let's not give it to them outright. Let's give it to them in what we call a credit shelter trust, so that we're protecting them from divorces, for example. That's a big one, right? Divorces, or their own lawsuits, their own problems. So we have a unique opportunity when somebody passes away to give the money to your beneficiaries in a way that completely protects the beneficiaries, at least with your money. They have their own money. They could lose their own money to these issues, but they won't lose your money to those issues. And so that's pretty cool that you can do that.
Yeah.
And yeah. So, and another thing is, if let's say one of them is not good with money, they're just really bad with money. So we don't need to protect them from anybody else but themselves. All right. Well, then we can again say, you know what, Johnny, I love you. You're going to get 1/3 just like your brother and sister, but you're not going to be in charge of your money. Your brother's going to be in charge. And if he can't do it, your sister will be in charge. And they're going to take good care of you and give you money for things, but they're not going to let you blow it. And a big situation where we've done this is with people with addictions. Because if you give $100,000 to someone with an addiction, that could be a bad thing. That really could be a bad thing.
From someone who has an addictive, May 1st, I will be 10 years sober. So I would absolutely agree with you that would be protecting an addict from themselves, because they wouldn't. The other thing, not even would it be detrimental because we would have this abundance of money, but we're not qualified to know what to do with it, because in that state, in addiction, we're not in the state of mind to know how to manage our lives properly.
Right. You'll have friends come over and hang out with you, and then when the money runs out, they'll disappear. I've heard that several times with people. People that get a check every month, and the friend comes and visits for a week, and then the money's gone, and he comes back the next month later.
Yes, it's amazing how that world works. I'm so grateful to be where I am and be having these conversations instead.
Right. This is a much better conversation than that.
This is good stuff. Wow, I'm excited. So the next question I have is, how does estate planning address the needs of blended families or complex family dynamics?
Yeah, so whenever I think of this question, I think of the old TV show, The Brady Bunch. Okay, so you have I don't remember all their names right off the top of my head, but you had the two blended family. You have 3 girls on one side and 3 boys on the other, and they're married, right? The parents are married, and everything seems to be going pretty well for the most part, except for those middle kids. But what happens if one of them passes away? Because now, how do we make sure that, first of all, that the surviving spouse doesn't disinherit those other kids that they never really liked anyway? I always say that, well, I don't like those kids. I'd like to, screw them out of the money and make sure they only go to my kids. So that's a concern for some people. And I when I have a family that has their own set of kids, they just have, 2 parents, 3 or 4 kids, and they're joint kids with everybody. I don't worry about this at all, right? Nobody's going to disinherit their own kids typically. But the blended family situation is a big risk that's going to happen. So, after a couple of years, they find somebody else, they get married again, and there's just a falling out. Those other kids just don't hang around anymore. They don't send a card for Christmas one year, or they don't send a birthday, or they just, and all of a sudden, well, those kids don't care about me anymore. I never hear from them anymore. So I'm going to write them out of the trust, let's say. So that's the scenario. And how do we plan for that? So there are several things we can do to plan for that. One is to make part of the trust irrevocable when one person passes away. So let's say dad passes away, we take his assets, his half of the assets, and put them into a trust for the benefit of mom, or I should say stepmom. We'll call stepmom. Let's say it's for her life, and she has so much access to that, but she can't take all of it out. Let's say, and then when she passes away, then it goes to his kids. All right. So that's one way to do protection. And another way that we do it as well is, let's say both parents, or they're trustees of their trust, right? And they both pass away. We'll have one kid from each side of the family be co-trustees together. And that way we're looking out for both sides of the family. We're making sure that both sides are represented as they administer the trust and divide it up among all of the kids. So those two work really well to protect that situation.
Wow. It's amazing how many things today I have learned from you that I wouldn't have even known to ask, or perspectives that many of us don't even think of. It's a lot of people ask me how much estate planning costs, and what what I'm gathering from our conversation is while there is an investment, the savings from what would be paid on the other end, both emotionally and financially, and with resources, is probably 10 times plus what the cost of what the investment would be.
Exactly. So yeah, an investment, like we talked about investment, right? It is an investment. You're spending some money, but you're getting much more in return. And we have several plans. We have plans that are inexpensive if you want a very basic plan, and we have plans that are pretty fancy and have those irrevocable trusts in them. And it's just regardless of which plan you pick, I can essentially guarantee that you're going to get your money's worth out of it. Avoiding probate, just having a trust to make sure you avoid probate, that's $3,000 to $5,000 plus right there. That you're avoiding that. Now, maybe you'll have a trust, you have to administer the trust, but it's typically less expensive than administering a will. So that's a big one right there. And then, of course, all of the pre-planning, putting your assets into the trust, protecting it from Medicaid or lawsuits, those kind of things. I mean, what is the return on that? That could be worth $1 million or more, depending on what you have and what you want to put in there. And then again, with the powers of attorney, the ability, even if we don't do the pre-planning and you're going into the nursing home, okay, with that financial power of attorney, we can save at least half of your money. So you have $300,000, you're spending $15,000 a month in the nursing home. We can save $150,000 of that with this power of attorney. And so how much is that worth? So yeah, definitely. There's a great return on investment for estate planning. Financially is one, but peace of mind, that's a big one too, I think. Some people, I talk to some clients and they say, well, I don't really care what happens. I'll be dead. And I say, okay, really? I mean, you're not going to care. If you care about them now while you're alive, you're still going to care that they are taken care of when you pass away. And so, but some people have that kind of attitude. But the vast, vast majority of people, they would like to make things easier for their kids if they can.
Thank you. Do you have anything? Well, actually, let me wrap up and kind of think of what I got from that too. So the best investment we can make in truly loving someone else and ourselves is to plan this, because it not only alleviates our own fear of the future, but it takes the pressure off the people that we love. And so truly loving them is planning ahead and relieving them of trying to make decisions for us. And instead, sitting down with someone such as yourself and planning out our own experience so that they can grieve and go through their own experience and honor the dying's wishes with integrity and compassion. And it can be a very graceful experience.
That's a great summary. I couldn't have said it better myself. I totally agree with that.
Beautiful. Do you have anything else you would like to add before we close today? This has been wonderful.
I would just urge people to check out an estate planning attorney. Sometimes I say that visiting one of us is kind of like a legal checkup. You go to your primary care doctor every so often. If you don't see an estate planning attorney, you might be due for a checkup to go through these kind of issues with you.
And tell us how one would get in touch with you to schedule an appointment and learn more.
Well, they could contact us. I think you can provide our contact information, hopefully. Yep. I'm with Legacy Estate Planning and Elder Law, and I'm in Rockford, Michigan.
Beautiful. Thank you so much, Charles. This has been wonderful. I appreciate, and I hope everyone watching appreciates all of his expertise and wisdom and experience. I know I have.
Thank you, Will. I appreciate it.